Good afternoon, everyone, and welcome to today's panel discussion, Who's to Judge? Protecting the Legitimacy of State Courts. My name is Zach Gima, Vice President of Strategic Engagement at the American Constitution Society, the nation's leading progressive legal network, with over 200 student and lawyer chapters in almost every state and law school around the country. Through our diverse, rapidly growing nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and realize the promise of equality for all. If you aren't already, I'd encourage you to become a member of ACS and to donate. Our work is more important now than ever, and we need your support. Go to acslaw.org where you can join, donate, and find more information about events like this one. A couple of housekeeping notes before we begin. We're not offering CLE credit for this event. This afternoon's discussion is being recorded, and the recording will be available on ACS's website after today's program concludes. I hope to incorporate as many of your questions as possible into today's discussion. And to submit a question, please use the Q&A box at the bottom of the Zoom screen. Now I want to introduce our panelists for today's discussion. Don Blagrove is the Executive Director of Emancipate North Carolina, an organization that advocates for racial justice and end of mass incarceration in North Carolina through education, mobilization, and litigation. Prior to this role, she spent 8 years as a post-conviction staff attorney with North Carolina Prisoner Legal Services. She has been recognized as leading voice in North Carolina on the issues of mass incarceration and institutional racism. Robin Sanders is an assistant federal public defender. She previously served as counsel in the Democracy Project's Voting Rights and Elections team at the Brennan Center for Justice and provided pro bono counsel for the Wrongful Convictions Clinic and Innocence Project at the Duke University School of Law. Robin also served as a law clerk for Justice Anita Earls on the North Carolina Supreme Court. Robbie Avalon is a professor of law and the faculty co-director of the State Democracy Research Initiative and former faculty advisor of the ACS chapter at the University of Wisconsin. He previously worked in private practice at Orrick, Harrington, and Sutcliffe, and served as a law clerk for Judge William Fletcher of the Ninth Circuit and for U.S. Supreme Court Justices Ruth Bader Ginsburg and Sonia Sotomayor. So thank you for joining us today. As I mentioned earlier, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy and uphold the rule of law. There are many current attacks on our country's democratic institutions. And what's happening in North Carolina right now is another five-alarm fire that may not be on everyone's radar. There's a lot to talk about, both sort of the ongoing litigation, how we got where we are. But Robin, would you mind sort of laying the groundwork for this discussion, talking about sort of what's happening with the North Carolina Supreme Court race? And again, even in that discussion, there can be many starting points, but perhaps the election day is a good place to start.
Yeah, thanks, Zach. And thank you so much for having me to discuss this really important topic today. So I am going to start with election day, but I do think it's important to just set the stage for our listeners to understand just how many lawsuits have been filed by Judge Griffin. So there was actually a pre-election legal assault that took place that began even before Election Day. And this is when the RNC filed a rather dubious complaint in which they said that voters should not be counted unless they provided their Social Security or driver's license numbers. And this is despite the state having already addressed this issue fully. And so this is a case that actually remains pending in federal court right now. And I think that this action, along with the 5 other lawsuits that have been filed, highlight, Judge Griffin and the GOP's determination to create barriers to voting and to steal an election in which Judge Griffin lost. But as Zach said, I think that the thrust of the media attention surrounding this litigation has been focused on 2 lawsuits that were filed by Judge Griffin. And so turning to election night last November, the race for seat 6 on the North Carolina Supreme Court was held between Justice Allison Riggs, who's the current incumbent on the court, and Judge Jefferson Griffin, and he is a judge on the North Carolina Court of Appeals, which is the intermediate appellate court in the state. And the North Carolina Supreme Court is the highest court in the state. And so this was a tightly contested race. On election night, Griffin held a lead over Justice Riggs, but as the full tally emerged and as all of the legal ballots that were cast were counted by the state election board, including provisional ballots, Justice Riggs steadily chipped away at Judge Griffin's advantage and ultimately prevailed over him by 734 votes. So the real election offensive, as I call it, erupted after the election, after it was declared that Justice Riggs was in fact the winner. Instead of accepting this outcome, Judge Griffin launched a relentless legal assault and campaign against her. And he filed multiple challenges with the North Carolina State Board of Elections, challenging the election results. And he alleged that there were several issues with a significant number of ballots in the election. So he started off his campaign by filing over 300 protests with the County Board of Elections, and he challenged the eligibility of over 60,000 North Carolina voters. And this, again, is just a shameless effort to disenfranchise tens of thousands of citizens in North Carolina who properly and legally cast their ballot in this election. And I would say that the lawsuit kind of falls into three buckets, or there's three buckets or tranches of votes that he was challenging. Number one, it was ballots cast by people who he claimed were not legally registered to vote due to incomplete registrations. The second, bucket of ballots was votes cast by overseas citizens who he alleged were not North Carolina residents. And then the third, the acceptance of ballots from military and overseas voters who he claimed did not provide a photo ID. But importantly, as Justice Riggs and the North Carolina Board of Elections has stated in their defense to this ridiculous lawsuit, is that he has not been able to show even one single voter was ineligible or voted illegally on the day of the election. Every single voters' votes that he's challenging were cast legally and cast in accordance with the laws of the state in the election at the time of the election. So the State Board of Elections ended up holding a hearing on the challenges, but they ultimately dismissed all of them on both procedural and substantive grounds. The board also importantly engaged in 2 recounts and ultimately confirmed again that Justice Riggs won the election fair and square, and that every single eligible voter whose ballots were cast were counted in accordance with the state laws, and that he lost this election. And so as a result of the state board not indulging in his ridiculous protests, Judge Griffin proceeded to wage this campaign with the courts. So in what I would call a strikingly partisan maneuver, he cherry-picked votes and targeted voters' ballots that he wanted to challenge in court. And I think it's important to also note that as the amicus briefs filed in this case talk about, Judge Griffin targeted disproportionately Black voters, which, as we know, evokes a very troubling and heinous history of voter disenfranchisement and suppression against African Americans in this country and in the state by both federal and state officials. And he also challenged voters who voted in heavily Democratic districts. So again, very telling indicia of a partisan maneuver that has no basis in legal fact or in law. So after he was dissatisfied with the board's decision to deny his protest, he filed what's 2 separate lawsuits that I want to focus on today. So the first is known as Griffin 1, where he filed a petition for a writ of prohibition in the North Carolina Supreme Court, which is again the state's highest court. And then he also filed a petition for review in the Wake County Superior Court, and that's known as Griffin 2. The State Board of Elections sought to remove those cases, and remove means that they sought to take the case from state court and have it litigated in federal court. And what happened, so I guess I'll start with Griffin 1. So in Griffin 1, he filed this petition for writ of prohibition, which is essentially a legal maneuver for him to leapfrog over the normal judicial process of having the challenge heard through the normal channels of the court, which would be in the Superior Court first, and then it would proceed to the North Carolina Court of Appeals. And he essentially just was asking the court to declare him the winner of an election he lost. He also requested in that action that the court stay or pause the board's certification of the election, which would ultimately declare out Justice Riggs the winner. The board, as I said, subsequently removed this case to federal court. So during the pendency of that appeal, the North Carolina Supreme Court actually dismissed Judge Griffin's petition for writ of prohibition. And this was while the case was pending on appeal in the Fourth Circuit after the district court determined that the case should properly be heard first in state court. Ultimately, the Fourth Circuit heard oral argument in that appeal, and they agreed with the district court that it was proper for the district court to send the case back to state court and that it should first proceed through state court. But importantly, it retained power or jurisdiction, as we say in legal speak, over the federal issues that arise in that case. And so that's what happened with Griffin 1. And then turning to Griffin 2, that was the case that he filed originally in the Wake County Superior Court challenging the protests or the denial of his election protests with the North Carolina Board of Elections. So that case was actually heard recently on February 7th by Wake County Superior Court Judge William Pittman. And on the same day that the court heard hearing in that case, Judge Pittman ultimately affirmed the North Carolina Board of Elections decision to deny those election challenges. And the court concluded, quote, that the board's decision was lawful and not in violation of constitutional provisions. So as a result of Griffin's lawsuit being rejected at the Wake County Superior Court level, he then subsequently appealed that decision to the North Carolina Court of Appeals, which is again the intermediate appellate court. So as it stands right now, the North Carolina State Board of Elections filed a bypass petition on February 17th. And essentially what that petition is it asks the state Supreme Court to take up the dispute that's currently pending before the Court of Appeals right now. And Jefferson Griffin opposed this request, and he's actually asking for the Court of Appeals to expedite briefing in the case. The board and Justice Riggs, as an intervener in the case, argued that immediate review by the state high court is appropriate because this is a case that involves a significant question of public interest, that there's a potential for substantial harm if the court review is delayed in this case, and that this is something that needs to be handled swiftly because of the fact that we are now 4 months after the election day in which Griffin was declared the loser, and we are still litigating whether or not Justice Allison Riggs, who won the election, should retain her seat on the court. And then finally, I just wanted to mention that there's a lot of potential outcomes in this situation, but if the justices on the court ultimately grant the board's petition to bypass the Court of Appeals, and there's hypothetically a deadlock or a 3-3 split on the merits or the legal arguments underlying Griffin's case, then the Wake County Superior Court's denial of his challenge would remain in place. But if the justices reject this bypass petition and allow what is right now a Republican-dominated Court of Appeals to hear the case first, which is what Judge Griffin is asking, then an evenly divided ruling from the state's high court could enable the Court of Appeals ultimate decision to stand in this case. So there's a lot of moving parts, a lot going on, but ultimately I think it's important for folks to understand that this litigation has persisted for months, that Judge Griffin is the loser in this case, that there were 2 recounts, that his challenges were robustly reviewed by the State Board of Elections as well as the district court in this case, or the Superior Court rather, and he is still persisting with this legal assault against Justice Riggs to declare himself the winner in an election that he lost.
That's a lot, and I'll also say that summary of litigation was fantastic, and actually thank you for starting before election day because, as you mentioned, this story does not start with the current litigation, but also doesn't start with this race and this attempt to sort of steal the election. Don or Robin, can you talk a little bit about the history of North Carolina Republicans and their assault on the courts and democracy. And again, I know we only have an hour for this conversation, but can you sort of tell a little bit of that story in this context?
So let me just first say thank you for having me. And also that Robin killed that summary of this very complicated litigation. That was incredible and hats off to you. But let me be clear. While we can get and we need to understand the minutia of the law, it is very important for us to understand the global picture of what is happening here. North Carolina, General Assembly and the judiciary are colluding and have been colluding for a very long time to undermine democracy in North Carolina. This attempt to steal an election by a current Court of Appeals judge who is trying to get on the highest court in our land is shameful. But what is more shameful is the fact that the Republican Party has not robustly stopped this ridiculousness, that they have not, that they are colluding with Griffin to steal a seat on the Supreme Court. Now, how do we know that they're trying to steal a seat? Well, because not 6 months ago, they tried it in a different way. Justice Anita Earls is the only Black woman that sits on the North Carolina Supreme Court. And less than a year ago, an ethics complaint anonymously was filed against her, which could have eventually had her removed from her seat by none other than her fellow justices on the Supreme Court, much like what we anticipate will happen here if Griffin's challenge is allowed to go to the Court of Appeals first and then up to the Supreme Court. What we expect to see there through very treacherous technical maneuvering is literally the Supreme Court giving its friends and its conservative friends another seat on the court. Now, make no mistake, they already have a majority. They don't need this seat. This is about greed. This is about total domination. And this is about the ultimate demise of democracy in North Carolina, which is what we are seeing. And if this election is allowed to be stolen, what we can anticipate throughout the country is to see this same tactic used to steal elections and to undermine democracy all over the country. Right now, North Carolina is the canary in the coal mine as it relates to the last gasping breath of holding on to our democracy. And if we allow Griffin to steal this election, if we allow the Republican Party to steal this election, if we allow the General Assembly here in North Carolina, and the judiciary in North Carolina to continue to collude, we will no longer be a democratic state, and we are well on our way to no longer being a democratic country.
Thank you, Don. And as you sort of connect the dots between sort of the history of the North Carolina Republican Party, sort of their attack on democracy in North Carolina, I'm going to turn things over to Rob to talk a little bit about where this has happened in other states, including your home state of Wisconsin, and sort of other trends that these attacks are a part of.
Sure. Well, first of all, thank you for having me, and it's great to, I've followed events in North Carolina from afar for quite a while, but it's great to be on a panel with folks who have just such deep on-the-ground knowledge of events that are going on there. But my role is to zoom out a little bit and maybe put this in a little bit more of a national perspective. And the reality is that, what we are seeing in North Carolina is also happening in a number of other places. And I'll identify a couple of distinct strands of the behavior in North Carolina, one of which is primarily about voting rights and electoral participation. And then the second one is more about the status and stature of courts in our system. And both of these go to, concerns that are unfolding across the country about the strength or erosion of our democratic institutions. So first of all, in terms of the voting rights aspect of this, what we're seeing play out in the litigation that's unfolding in North Carolina right now, it really harkens back to the spate of lawsuits that we saw following the 2020 election, where courts around the country were asked to intervene after the fact to swing the election to President Trump after the vote counts showed that he lost. And the claims in those lawsuits were wide-ranging, but they included arguments that certain ballots should be thrown out based on alleged procedural defects in how those ballots were cast, even though every indication was that the ballots were cast by qualified voters, and those voters had followed the rules and guidance that they had been given by elections officials before the election. And the good news in 2020 was that judges from across the ideological spectrum rejected those lawsuits. The courts in those cases recognized and took seriously the interests of voters who were, in fact, acting in reliance on the rules and guidance that they had been given. And the courts recognized that in those circumstances, it wouldn't be appropriate to disenfranchise individuals. So, Wisconsin, my home state, was one of the states that saw some of this post-2020 litigation. And our state Supreme Court, which then had a conservative majority, rejected the claims. And one thing that it noted would be to throw out votes after the fact, to penalize voters who relied on established policies, our Supreme Court said would be, quote, beyond unfair. And it would, quote, violate every notion of equity that undergirds our electoral system. Now, despite the lack of success of those claims after the 2020 election, we saw in the run-up to the 2024 election efforts around the country to lay the groundwork for what almost certainly would have been another round of similar litigation and attacks had the 2024 election come out the other way. And what we're seeing in North Carolina, I think, is an indication of what we may have seen in other states had the results in November been different. Now, I can also connect this to just other things that we're seeing about the right to vote, and I won't go on in too much detail about this, but in many states, we have seen efforts to do things like purge voter rolls in careless ways, take people who are likely to be eligible off the rolls. We've seen efforts, and there's still pending litigation about this, to do things like override state laws that allow absentee ballots to be counted as long as they're postmarked by Election Day. There's litigation about this ongoing in the Fifth Circuit. There's litigation ongoing that's now reached the Pennsylvania Supreme Court about whether we should be throwing out absentee ballots simply because of a quite immaterial error in whether or not the voter hand wrote a date on the external envelope. Right. And so these are ongoing fights, right, that extend well beyond judicial elections, but go to our elections and voting rights more generally. Now, the second strand of this, though, is more specific to courts and the status of courts across the country. And there have been an array of efforts around the country, many of them emanating from gerrymandered state legislatures, which has been the case in North Carolina, efforts to undercut judicial independence and integrity and reduce the likelihood that the courts are going to provide a meaningful check on political actors. And so, I mean, let me I'll identify 5 categories of these kinds of actions and try to run through them fairly quickly. Again, just to give you sort of the lay of the land, and this is not an exclusive list. So what's one thing that we've seen, including in North Carolina, we've seen a shift in some states from nonpartisan to expressly partisan judicial elections. North Carolina made that change in 2016 at the behest of the Republican-controlled legislature. Even more recently, we've seen a shift to partisan judicial elections in Ohio that took effect in 2022. And it was Republican lawmakers there who pushed that change. At the time, the Ohio Supreme Court was providing a meaningful check on the legislature, including in the context of gerrymandering. And that move, that shift to partisan elections in a state that had shifted in the Republican direction in recent years, means that today the Supreme Court in Ohio really is dominated by expressly Republican judges who are today much more of a rubber stamp than an active check on the legislature. Okay. And just within the last month, I would note that lawmakers in Montana introduced legislation to try to shift judicial elections in that state from nonpartisan to partisan elections, because that court too in Montana has actually been quite a robust check on some of the overreaching of their state legislature. So, second category of activities that we've seen at the state level, we've seen some court packing. This is discussed occasionally at the federal level, but we've come nowhere close to actually expanding the US Supreme Court. But there are a growing number of state legislative efforts to change the size of state high courts, and in a couple of instances, those efforts have been successful. In 2016, Republican-controlled legislatures in Arizona and in Georgia added 2 seats to each of those state Supreme Courts, which were filled by the state's then Republican governors. Right. And there are ongoing efforts in other places to try to expand courts in order to shift the balance of those courts. A third thing that we have seen is proposals in some states to shift the way that state Supreme Court justices are elected from statewide elections to districted elections. The norm around the country, there are a few exceptions, but the norm is for state Supreme Court justices to be elected statewide. Well, what happens if you shift to districted elections? Well, that means that the districts can be gerrymandered. And so this is a way to try to exert more control over the composition of state Supreme Courts. A fourth phenomenon that I'll mention, there are a number of states that used what's often called merit-based selection systems for state Supreme Court justices, where justices are initially appointed, and they're appointed from a list that comes from a judicial nominating commission, and then later they'll run for a retention election. And those judicial nominating commissions are supposed to be independent, and as the name merit selection implies, they're supposed to be identifying the most meritorious candidates for these jobs. But there have been efforts in a number of states to capture those commissions and give partisan actors a greater role in choosing the potential appointees. And so those efforts have been successful in recent years in states like Idaho, Iowa, Utah. Utah, until recently, had a merit selections process that was structured to avoid giving either political party majority control. The state in 2022 eliminated that partisan balance requirement and instead shifted control to the governor. And then finally, let me mention the weaponizing in some states of judicial conduct commissions. Right? It was already mentioned that Justice Anita Earls in North Carolina has been investigated by one of these commissions and potentially could have been removed from office based on simply comments that she made about implicit bias and lack of diversity in the judiciary. But that was considered enough basis to initiate an investigation against her. In Wisconsin, we had a complaint that was brought against one of our justices, Justice Jill Karofsky. And so these ethics commissions are sometimes being used less to actually root out real problems in the judiciary and more to harass judges. Now, related to that, right, these judicial conduct commissions can be hugely valuable. They were developed as an effort to safeguard against judicial corruption and impropriety. And if you think about some of the complaints about the lack of enforceable ethical standards that we have for US Supreme Court justices, you want some kind of institution like this to exist. But as with the states that have shifted control of their judicial appointment commissions, there has been an attempt in some states to shift control and weaponize the judicial conduct commissions by changing their membership. In other words, to give partisan actors control. And so, we've seen states, including most recently Louisiana, amend its constitution just a few months ago to add 5 new members to what was previously an independent judicial ethics commission. And now those 5 new members all will be appointed by partisan elected officials. And there have been other states where we've seen these kinds of shifts as well. So I could go on. There's more mischief afoot, but I think that gives you at least a little bit of a flavor for what we're seeing around the country.
Thank you for that. And I think it was a great sort of overview of the different types and categorization of sort of the different attacks on our institutions. I want to drill down a little bit on the attacks on judges and then the court. But Dawn, I don't know if you want to jump in and react to that or anything that Rob said.
I just want to talk a little bit about what we're seeing, what we saw here with Justice Anita Earls and the attack on her. As was mentioned earlier, she was facing an ethics complaint that could have resulted in the Supreme Court disbarring her for essentially exercising her First Amendment rights. And someone in the questions asked, is there any good news? And yes, there is good news. Anita Earls fought back, filed a lawsuit against the ethics board and for violation of her First Amendment rights. And while that lawsuit was not ultimately successful, what was successful was a very strong campaign from the grassroots that was launched, calling this action of trying to disbar Anita Earls and remove her from the state Supreme Court as what it was: very racist, very misogynistic, very much an attempt to take North Carolina back to Jim Crow. And because of that very strong opposition from the people, the state essentially blinked and dismissed the lawsuit, and Anita Earls was allowed to keep her seat. We are very hopeful that with the same types of tactics and even more direct and hard-hitting tactics that we are using on the ground here in North Carolina from organizers Common Call, Democracy NC, Emancipate NC, Advance Carolina, organizations here that are holding rallies all over the state of North Carolina, raising the attention and raising the outrage of people about what is happening here in this election, and the real long-term ramifications of what happens if Griffin is allowed to steal this seat. And people are listening. People are fired up, and we are seeing, and we believe that when the people fight, they will win. And we believe that Griffin will ultimately be forced to either drop this litigation altogether or to be excommunicated from his party because of the shame that he is bringing on it.
Thank you.
Robin, I'm going to pass to you.
Yeah. Yeah, go ahead, Robin.
No, thanks, Don. I'm glad that you mentioned that, because that's one of the things I wanted to zero in on too is, and as Rob was saying, one of the ways that judicial independence is being undermined is this weaponization of judicial ethics bodies. I think it's important too to go back even before those two complaints were filed against Justice Earls. In January 2022, you had Republican legislators in North Carolina that were seriously discussing and publicizing the idea that they would impeach her and another Democratic member of the court at the time for striking down the extreme partisan gerrymanders and maps that legislature was enacting and had enacted in 2021. So I think, as Don said, it's really hard to overstate just how treacherous and anti-democratic and frankly abusive and unethical that action would be. But simply put, it would have allowed legislators to threaten impeachment of any judge who handed down a ruling that they disagreed with, even though they're constitutionally authorized to interpret or to ensure that the acts of the legislature are in line or consistent with the Constitution. So it was very egregious, and that was something that was going on all throughout that year when the case of Harper versus Hall was pending before the court. And so that was one of the attacks that Justice Earls had to weather. And then, as Don said, then you go to, you fast forward to 2023, where she had to weather not just one, but two baseless allegations that were filed with the Ethics Commission about her alleged unethical behavior, one of which referenced comments that she made about administrative changes that were public at the time, which she is entitled to do, well within her rights to do. It's not unethical to inform the public about public information. And as Don said, the second instance was a flat out racist attempt to push the only Black woman judge on the high court off of the court in an aggressive and lawless way. And then finally, I wanted to mention that even Justice Allison Riggs has been targeted in this way with the use of the Ethics Commission. There was a complaint filed against her where senators tried to argue that public statements she made about her positions on issues like abortion rights compromised her impartiality as a judge. I think it was very admirable. Once again, just like Anita Earls, Justice Riggs defended herself vehemently, and she asserted that she had every right to inform voters about her values and her commitment to judicial independence, and that she was not going to be intimidated by these awful, outrageous attacks by Republican legislators to undermine the independence of the judiciary and to threaten and intimidate and punish any judge who so much as even tried to do what they were constitutionally appointed to do. So I think, again, like Don said, it's very important to talk about this and to understand that it's transparently and nakedly partisan. And in the case of Justice Earls, it's very racist because she's the only Black female justice on the Supreme Court.
And I just want to quickly, just so that we're clear about the strategic and insidious nature of the attack on the progressive judiciary in North Carolina. The other judge that was targeted in that gerrymandering case was a judge named Brian Collins. And since then, while they were not able to, they did not impeach him, but in the last budget, during budget discussions and when they were reconciling the budget, they did eliminate his judicial district. So he is no longer on the bench at all here in North Carolina. And I think that it's important to highlight that because what we are seeing here in North Carolina is a strong collusion between our judiciary and our legislative branch. What the judiciary branch is unable to do because of pushback, the legislative branch is clearly doing when it is eliminating the judicial districts of judges who are truly fighting for the people and following the letter of the law. So we need to be very careful in North Carolina, and everyone in the country needs to pay close attention to what's happening here, because what we have, again, is a deep collusion between the judiciary and the legislative branch, and where that exists, democracy cannot.
Thank you, Don. I want to sort of zoom out slash sort of tie together a couple of themes that are coming and maybe and also in the question. So it sounds, the sort of one of the reasons we're having this discussion is to talk about sort of why state courts are the battlegrounds for these discussions about power. You can kind of think, why are conservatives so focused on the courts? One, you mentioned sort of greed or racism, but also sort of there's the power in the state court system that this clearly represents. And Rob, I know through your work at the State Democracy Research Initiative, you focus on sort of the power of the state courts and what can be done in them. So can you talk just a little bit, about sort of the power of the state courts and sort of why these attacks are happening at this level?
Sure. I mean, I think there are several reasons for it. To start, though, and I think this is fairly obvious probably to most people who are listening, state courts increasingly are finding themselves at the center of an array of high-stakes, hot-button issues. Issues like abortion, issues like partisan gerrymandering. And that's happening in part because with respect to some of these issues, the U.S. Supreme Court has directly pushed those issues down to the state level. Right. In Dobbs, for example, the court said, the U.S. Supreme Court said that it was returning the issue of abortion to the states. The U.S. Supreme Court effectively said the same thing in Rucho versus Common Cause, when it said that you can't bring partisan gerrymandering claims in federal court, and it directed litigants to the states. And so these high stakes cases that in the past might have stayed in federal court are increasingly finding their ways to state courts instead. And then even when you don't have that kind of direct instruction from the federal courts to go elsewhere, litigants have increasingly gotten the message that certain types of claims are just not going to get very receptive treatment in today's federal courts. And so there are groups and individuals that in the past may have gone to federal courts to try to protect civil rights, try to protect voting rights, and they would like, to the extent they can, to turn to state courts instead. And, we've actually charted there has been a discernible increase in the amount of state constitutional litigation that we've seen around the country in recent years. And litigants and others are increasingly recognizing that state constitutions and state law might be an untapped resource to protect rights that otherwise aren't going to be protected. But you need to have courts that are receptive to doing that. Another reason that state courts have become such a battleground is that in this polarized era, this era of kind of winner-take-all politics, where you have some political actors that really want to assert their domination over their partisan adversaries and over other institutions, that really puts pressure on courts. And so courts have become a battleground because there are some folks who don't want them to remain remain that kind of independent check, the check that they have the potential to be. And then the final reason that I'll mention why I think courts have really found themselves at the center, state courts have found themselves at the center of some of these storms, is that the people in most states have opportunities to reshape their state Supreme Courts, opportunities that don't exist in the same way with the U.S. Supreme Court at the national level. We do have in most states some form of judicial election, whether it's direct election of judges or retention election of appointed judges. And so there are ways to hold judges accountable. There are ways for the people to have a say in how they think that their laws should be interpreted. And so, there is the possibility for state courts to be harnessed to really serve the people's desires in many cases to protect fundamental rights, to protect the democratic system. But at the same time that there are those opportunities for state courts to do that important work, state courts are also somewhat more vulnerable than federal courts because the elections can turn out the other way. The courts can be manipulated in some of the ways that I was mentioning earlier, right? And so what has that meant on the ground? It's meant that we've had huge financial investments in state Supreme Court elections, right? These elections have been nationalized in ways that wasn't true in the past. There was more than $50 million spent on Wisconsin's 2023 state Supreme Court election. We have an election for our state Supreme Court coming up in April, and there may be even more money spent on that race, and it's already drawing national interest. So that's where state courts are finding themselves these days, right? They really are at a point where there is a lot that they can do, and there is in many cases a lot that some actors don't want them to do, and so here we are.
Thank you for that. And also I want to flag if you have questions, please put in the chat and we're going to try to incorporate them as we go along. Dawn, I want to lift up sort of the answer you put in the chat as it relates to either both good news and hope. And I also want to say at the end of this discussion, we'll talk a little bit about sort of concrete things that folks can do to combat these attacks that we're talking about. Robin, I want to lift up this question from the chat for you. You did a extremely thorough job of discussing the state litigation, and there are other layers to this, and so one of the question is sort of if Judge Griffin prevails at the state level, are there opportunities for sort of this litigation at the federal level to perhaps overturn a state court decision?
Yeah, so I think the crux of the argument is that because he is attempting to essentially rewrite state election laws after an election, that violates federal law and a number of federal statutes and laws that protect voting rights. So I think the main thing for people to understand is that what he is trying to do is flatly illegal under federal law, and he's essentially trying to challenge a whole tranche of ballots and over 60,000 voters' votes that were legally cast at the time of the election in accordance with state law at the time. And so he's trying to retroactively change those laws, which is a clear violation of federal law. So I think ultimately what we have to do is just to wait to see how this plays out in state court first, because the Fourth Circuit, as I said, agreed with the district court in remanding or sending the case back to state court and allowing the process to play out there first before it would retain its jurisdiction over the federal issues that this lawsuit implicates. But I think it's important for people to understand that that is a clear violation of federal law, which is trying to retroactively change the rules of the game after the fact because you lost. And again, it's interesting because I think one of the other things I wanted to mention was that that the state Supreme Court, there's at least 5 justices on that court. So Justice Riggs is going to be recused because obviously she's part of the lawsuit. So you have the Chief Justice, and there's at least 3 other justices on the court along with him who are very sympathetic to Judge Griffin's claims and have signaled that in their ruling when they dismissed the petition for writ of prohibition. In fact, the Chief Justice, as I said in my Slate article, it was breathtaking, but he actually mentioned in the order that, it's not unlikely, or it's not uncommon, or even confusing, that voters would be suspicious about the integrity of the election because Judge Griffin was leading on election night, and his lead evaporated after election night as all of the eligible ballots that were cast were being tallied. I think that is, I mean, again, it's a breathtaking statement to come from the person who's tasked with overseeing the entire state's judiciary, but to suggest that the normal process of our elections, which is every ballot legally cast needs to be counted before a winner is declared, to suggest that that process, the normal process of our elections, is somehow nefarious or suggestive of some sort of illicit behavior is outrageous. And I think it does supreme damage to the confidence that our electorate puts in the electoral process and the integrity of our elections. It calls into question whether or not those tasked with counting ballots are somehow engaged in illegal behavior with no evidence whatsoever that that's the case. And so again, I think that the language that we're hearing and the rhetoric that's coming from the justices who eventually will likely decide this election, unfortunately, is very damaging and troubling, because it signals that they are not only indulging in, this litigation, but that they are sympathetic to the baseless legal claims that Griffin is raising in his lawsuit. So I think we just have to, unfortunately, we have to wait, as Don said, to see whether or not Judge Griffin finally, in all of his wisdom, decides to end this assault, or if he will continue to press his legal claims until the state Supreme Court ultimately decides who the winner of this election is, even though the people of North Carolina decided that the winner was Justice Riggs in November.
And again, just to give, first of all, I just want to say the lawyer in me is just tickled pink about the possibility that we could have real briefing on ex post factos in 2025. But let me just also say that the remarks that Robin just referred to are just the tip of the iceberg that we have seen from this Chief Justice here in North Carolina. During his election, he literally referred to Justice Anita Earls as North Carolina's AOC, and that he was coming back and he was fighting for this so that he could push back the AOCs of North Carolina. In many of the opinions that have been issued by this court, the public opinions that have been issued by this court, this Chief Justice and another Chief Justice Berger, who happens to be the son of the highest holding legislator in North Carolina, calls Anita Earls crazy, says that her ideas are delusional, and that her analysis of the law is stupid. These are real things that have shown up in public opinions from this Court of Appeals. From this Supreme Court. North Carolina has a real problem. We have a real problem with racism. We have a real problem with sexism, and we have a real problem with a Supreme Court who fails to recognize the systemic and institutional racism that exists throughout the judicial system and will do anything to pretend as though it doesn't exist. And if we have a judiciary that is not staying abreast and is not sympathetic and empathetic to the worldview of all folks, what you do not end up with is a fair and balanced judiciary. And that is what we are seeing here in North Carolina.
I want to zoom in on a couple of things stemming a little bit from the questions in the chat and some of the things that was mentioned earlier. Sort of about this case and litigation as it were. So, what are the potential remedies, or what are the likely sort of resolutions? Robin, you referenced sort of waiting for us to hear what the ultimate sort of, whether it be the Court of Appeals or the North Carolina Supreme Court decide as to what happens with this election. Is it that they will just go ahead and deem Judge Griffin the winner of the election despite having fewer votes, or and I know there's precedent from this in North Carolina, a revote or a redo of the election?
I think they would just declare him the winner, but I think ultimately, I don't really see how there could be a re-election. I think they would just throw out the ballots that he's challenging and say that as a result of these ballots being thrown out, he overtakes the original lead that Justice Riggs holds currently. Um, but what I was saying earlier is that this, as of right now, the Supreme Court has actually stayed certification of the election until this process plays out. And so that's, I think, another one of the extremely harmful results of this litigation is that it wasn't dismissed outright or out of hand. They've actually stayed certification so that this is the only election in the country that still remains uncertified to this day, is the state Supreme Court race.
And I think it's also important to recognize that this legal challenge is not throwing out these voters, these 60,000 voters that he's challenging. It's not throwing out their votes in any other election that they cast in the state. All of their other state elections that have been certified, these same 60,000 voters, their votes were cast and counted just like everyone else. This litigation is literally pinpointing just this particular race, which, if we're talking about election integrity, if we're talking about the invalidity of votes, that should go, that if they are invalid in one race, they should be invalid in all. That's what common sense says. But even here, just to highlight the absurdity of this litigation, they're not saying that these votes should be disqualified in every state election, only in this one. It's asinine. And the fact that our Supreme Court, the highest court in North Carolina, not only is entertaining this foolishness, but is giving it credence by putting a stay on the certification of the election, should give every North Carolinian and every American pause. Because again, we are not seeing an independent judiciary. We are not seeing the checks and balances. And without that, we do not have democracy.
And I just wanted to add one more thing to what Don said as it relates to independence. There's credible reporting now that at least one of the judges on the Court of Appeals has actually financially contributed to Judge Griffin's legal assault. And so, we don't know who will be compromised the panel if it in fact is heard in the Court of Appeals and it's not bypassed. But the fact that there's at least one judge, and there's some reporting that suggests more than one judge, who have financially contributed to Judge Griffin's legal fund to continue this legal assault is outrageous. And again, that would, by any standards, that's a conflict of interest, and those judges should be recused from hearing the case. But there's been no suggestion at all that any of those judges are even willing to entertain the idea that they shouldn't be sitting on a case where they've financially contributed to one of the litigants in the case.
I know one of the themes and the questions in the chat is sort of what can folks do? What are outlets for action? Where is their hope? Don, you referenced sort of the protests that have been happening sort of in North Carolina on this very issue over the last couple of weeks. And hopefully the more groups like ACS and others can do to highlight this whole list of, shocking in some regards, and the shocking sort of web of sort of interest and partisan affiliations and attacks. I think, and it's critical to getting people understand sort of really what's happening. But Don, I see. You want to jump in?
I was just gonna reiterate that the people of North Carolina are paying attention, and while judicial elections can sometimes be esoteric, this one has become very real to the people. And across the state of North Carolina, we have seen protests and people show up in the thousands to understand and to voice their deep concern about what's happening in this particular race. In Raleigh, North Carolina, just yesterday, day before yesterday, in the freezing, blistering cold, I want you to know, we had, I'm sure, well over 500 folks show up just in that city. Simultaneous protests were happening all over the state, where hundreds of people were showing up to protest. And it is taking notice. And the right to protest, when you have gerrymandered districts where the people's power is being seriously curtailed, where you have a judiciary that is not upholding the Constitution, the state or the federal Constitution in measurable ways. All that is really left for the people, and that was anticipated by our founding fathers, was the use of political protest and ultimately, revolution, challenging some of these systems who have forgotten that it is the tree of the people that holds up each of these branches, and that these branches are beholding to the tree, and that the tree are the people.
Another way in which, I hopefully this type of education can be helpful is to anticipate and be prepared for future similar assaults, whether it be in North Carolina or other places. I don't think whatever the end result of sort of this litigation will be the last time conservatives engage in sort of litigation related to election denials or sort of overturning the will of the people or other sort of attacks on the courts. Very specifically about sort of, well, I envisioned this question to talk about judicial elections, but I think really it doesn't necessarily need to be a judicial election. But in other statewide races, are there where might we see other sort of attacks on election outcomes?
Well, I think since Justice Earls is running to retain her seat next year, I wouldn't be surprised or shocked at all if this sort of assault, finds its way to her election. All we can do is hope that that's not the case. But given everything that we've seen over the last several years, as she was duly elected as a sitting justice, and the attacks that she's faced as a sitting justice, and of course now with Justice Riggs, I think that it's not beyond the realm of imagination that will ultimately play out again when she runs to retain her seat on the court. One other thing I wanted to add to what people can do is you can also donate to Justice Riggs litigation fund. Every little bit helps. Small dollar donations help. This is a very Judge Griffin's assault is bankrolled by very wealthy individuals and by the Republican Party itself. And I think it's important for individual voters, even if you didn't support her in the judicial race. I think any voter who cares about democracy, who believes in the sanctity of the vote, who believes that judges and courts should stay out of elections and that the election results should be dictated by what people how they use their voice at the ballot box, should be outraged and enraged by what's happening to her, and understanding very clearly that this could happen to anyone. And that I think one of the main purposes of this effort is to intimidate future leaders and public servants who want to serve North Carolina in this way or other ways, and to chill them from running, because they understand that there's a chance that their hard-earned victory will be challenged in court, and in the court of public opinion, in ways that are not only lawless but are totally unethical and have no basis in fact or law. And so I think it's important for people to understand that. And if you're a person who supports democracy, supports the sanctity of the vote, and doesn't believe in efforts to disenfranchise or steal an election, I think it's important to donate to her fund, because she's going to need every bit of it to continue to weather this attack.
We've got time for one set of questions. I'm going to sort of combine the last two questions here in the chat, and then turn things over to you all for some final thoughts. But there's questions about sort of enforcing North Carolina law or other laws to have Chief Justice Berger recuse himself, and also sort of talking about the legal point that sort of targeting one race is both legally and sort of on his face quite ridiculous. Can you address sort of the talks, the questions about sort of the legal process and what's going on with those?
So as it stands, the North Carolina Supreme Court essentially itself determines whether or not they need to recuse themselves in any situation. This issue has come up again and again as Justice Berger has been asked to recuse himself from cases that revolve around the constitutionality of legislation that is passed by his father's General Assembly. And what the standing rule is now in North Carolina on this Supreme Court is that if they think that they can be fair, that it's okay. So, excuse me, Griffin or any of the other strongly partisan justices on our Supreme Court, none of them have recused themselves in any situation. We don't anticipate seeing them recuse themselves anytime soon. And like I said, again, with the collusion between the General Assembly and the current judiciary branch, it is hard to see any laws being passed that would create a more stringent recusal process. And that's going to have to come from the legal community itself. And I am hopeful that we will see a strong campaign within the legal community to create some ethics opinions that seriously challenge whether or not someone should be able to stay on and hear and decide a case where there are clearly insurmountable biases.
Well, thank you for that. And I see we've run over time. If anybody has any last words, you all have been so eloquent and inspirational. I'd rather the last words come from you all than from me. So if you have anything you'd love to say, please just jump in.
I just wanted to say again, thank you for having me and for having Don and Rob to talk about this very important issue. I think, as I said in my slate piece, as a native of North Carolina, a former clerk on this very court for Justice Earls, and someone who cares deeply about voting rights and democracy, it's extremely angering and painful to witness what is happening in North Carolina and what is happening against Justice Riggs. But I am trying to remain hopeful that that ultimately justice will prevail in this case and that the people's voice will be heard, and that, you know, the fact that Justice Riggs was declared the winner in November will be the outcome that the courts will reach. But I think one thing that is very chilling about this entire situation is that regardless of whether the North Carolina Supreme Court ultimately rejects this lawsuit and confirms that Justice Riggs is the winner, it will be the courts and not the people that will have decided an election. And I think that is the central point and message that needs to be driven home, is that it doesn't matter whether they in fact rule in his favor or not on the merits. A court is deciding an election which millions of people cast votes, declared and rejected his candidacy, declared that they wanted Justice Riggs to be the winner, and it will be a court that decides and not the people. And that is fundamentally anti-democratic. It's tyranny. And I think we just need to continue to say that and to emphasize that no matter what the outcome, this has already set a devastating precedent in our state. And that we just have to continue, as Don said, to use our voices to amplify the outrage that we feel about this, and to let our elected officials know, including the justices who are elected, that we will not stand for this, and that we don't appreciate what's happening, and that we will use every single every single method at our disposal to fight back against this assault that's happening. But again, I would encourage everyone to continue to follow the litigation, follow reputable news sources that give updates about what's happening, and continue to find ways to use your voice and to fight back against this, and to join Justice Riggs in her fight to retain her seat.
Thank you all so much. I've learned a lot. I'm sure everyone else has, and we will be tracking this and other sort of issues that are happening around the country as we fight against sort of this tyranny, as you said, Robin. So thank you all so much.